So good afternoon, everybody, and welcome to the Front Desk. The business rescue and turnaround profession is strictly governed by a set of laws and a legislative framework that gives the profession its structure. However, the profession has received a lot of media attention over the past 2 years, and it is this attention that has highlighted that there are legislative gaps or loopholes that need to be addressed within the profession. Joining the Front Desk today is a panel of experts from Cliffe Dekker Hofmeyr to discuss this. Muwanwa Ramanyimi is an associate at CDH's dispute resolution practice. Cara Mayring is also an associate in the same practice. And Roxanne Webster, who is no stranger to turnaround talk, is a director in CDH's dispute resolution practice. Welcome, ladies. Muwanwa, let's start with you. Shiva Uranium was a major court case in 2021 in terms of setting a precedent in the profession when it comes to the appointment of a BRP. Can you please unpack the events that led up to the court case and the decision by the courts as it relates to the BRP profession?
Thank you, Jonathan. This case started in the High Court in 2018 and made its way up to the Constitutional Court. The matter revolved around Shiva Uranium, a private company which was placed into voluntary business rescue by its board of directors. The board appointed Mr. Klopper and Mr. Nwop as its business rescue practitioners. However, shortly thereafter, the IDC, being Shiva's largest independent creditor, wrote an application to the High Court to remove Mr. Klopper and Mr. Nwop as the business rescue practitioners. Prior to the application even being heard at the High Court, Mr. Klopper and Mr. Nwop resigned, and the court appointed Mr. Murray, who is a senior business rescue practitioner, as the new BRP of Shiva. The court also directed that a second BRP be appointed to assist Mr. Murray, and as such, Mr. Monyela, a junior BRP, was appointed to assist Mr. Murray in the proceedings. Since Shiva was a large company, a senior business rescue practitioner was required to conduct the proceedings. After several months, Mr. Murray resigned as the business rescue practitioner. Prior to Mr. Murray's resignation, him and Mr. Monyela passed the resolution to appoint Mr. Damnos, who was also a senior business rescue practitioner, to replace Mr. Murray. So because Mr. Monyela could not proceed because he was a junior practitioner, could not proceed on his own. Shiva's board was not happy with the appointment of Mr. Damnos, and as such, it passed its own resolution appointing Mr. Tayob and Mr. January as the BRPs. Mr. Monyela objected to the board's appointment to the company's tribunal. The tribunal decided in favor of Mr. Monyela. This is where the High Court case started again. The board appointed practitioners, Mr. Tayob and Mr. January, launched an application to the High Court to have the tribunal's decision reviewed and set aside. And for the court to declare that they, Mr. Tayob and Mr. January, together with Mr. Monyela, were the duly appointed BRPs of Shiva. Mr. Monyela and Mr. Damnos opposed the application. The High Court ruled that once a BRP is resigned, the board can only appoint another BRP with the authorization of the current BRP. In this case, it was Mr. Monyela. So the court based its decision on Section 137.2 and Section 137.4 of the Companies Act, which dealt with the powers and duties of the BRP. Therefore, the court dismissed Mr. Toyab and Mr. January's application. Mr. Toyab and Mr. January appealed to the Supreme Court of Appeal. The Supreme Court considered two issues. Firstly, they looked at the powers and duties of the BRP and held that these relate only to the management and day-to-day running of the company. As such, for any functions that falls outside of the day-to-day running of the company, the board is not subject to the BRP's to the authority of the BRP. Secondly, the court looked at the wording of Section 139.3 of the Companies Act, which governs the appointment of a new BRP in the case of resignations. The Supreme Court held that there were two scenarios that this section envisaged. One, in the case of a voluntary business rescue, the power to appoint a BRP lies with the board of the company. And two, in the case of a compulsory business rescue, the power to appoint a BRP lies with the affected person, which is likely a creditor who brought the application for placing the company in business rescue. Given that this was a voluntary business rescue, the court held that the power to appoint a BRP lied with the board of Shiva. Mr. Munyala was obviously aggrieved by the decision and applied for leave to appeal the decision to the Constitutional Court. The Constitutional Court held that the matter came down to one question, being who has the power to appoint the replacement of a court-appointed practitioner in the case of a voluntary business rescue. The Constitutional Court agreed with the Supreme Court of Appeal and also had regard to the intention of the legislature and the wording of Section 139.3. The court found that it was clear that in the case of a voluntary business rescue, it was the company who had the power to nominate a replacement business rescue practitioner. In the circumstances, the application for leave to appeal was dismissed, and Shiva's appointment of the two business rescue practitioners, being Mr. Tayop and Mr. January, were deemed to be valid. Just a few weeks ago, the High Court ratified the Constitutional Court's ruling, saying Mr. Tayop and Mr. January were indeed the BRPs of Shiva. This case is monumental because it draws a clear distinction between the powers of the BRP and those of the board of directors of a company in voluntary business rescue. So, thank you.
It sounds very interesting, and when I read it on the surface, it looks very confusing. And if we bear in mind the whole narrative that Deloitte's building, that there is a sort of crisis of trust that's sort of developing in the industry between creditors and lenders and the BRPs, it doesn't help when there is this jockeying for position in this. But we will discuss that a little bit later in further questions. Roxanne, let's come to you and another controversial business rescue that happened in Optimum Coal. What potential impacts could the court case that went through the courts and the decision by the courts have on the profession?
So, Jonathan, before we discuss what impact it would have on the profession, I think it's important for us to recap actually the whole Optimum Coal saga, because this is a very recent judgment that was handed down now on the 23rd of March. So we would all know, or ought to know, that the Optimum Coal Mine and Optimum Coal Terminal were actually culminations of proceeds that the Guptas had acquired through money laundering activities in Transnet and Eskom, and then they used those funds to actually purchase in 2016 these two lucrative companies. Those companies then obviously subsequently went into business rescue proceedings. The business rescue practitioners were appointed, and business rescue plans were actually put forward and approved by the creditors. Now, the NPA became involved later last year, and they brought two applications to, one, preserve the assets of the company, and two, to block a debt to equity transaction or takeover of the company, because this was essentially backed by a former associates of the Gupta family. So it would have seen these two companies going back to links of the Guptas. So they then brought those applications on the basis of the Prevention of Organized Crimes Act, and said that if the business rescue practitioners proceed with implementation of these business rescue plans, they may be liable in terms of POCA, because the funds were actually tainted or derived from money laundering activities. Now, the business rescue practitioners, on the other hand, obviously, they have a right in terms of Section 133 to refuse consent to bring these proceedings, which they obviously did. And their argument in doing so and during the proceedings in the High Court was that if the court grants a preservation order and also appoints a curator, that severely limits their duties as a business rescue practitioner in terms of the Companies Act to not only rescue the company, but also to deal with the assets of the company. They also mentioned that these business rescue plans were actually properly considered, they were put to the vote of creditors, and they were approved. And lastly, they also mentioned that these companies were actually in business rescue proceedings for about 4 years. So it had been quite a long time, and these employees actually are waiting for these funds, and they've gotten to a point where there is a transaction on the table that could provide for employees being paid out. But the court found in favor of the MPA on the 23rd of March and granted a preservation orders against these assets, and also uniquely appointed a curator to oversee almost the business rescue practitioners. So now we turn to deal with how actually it impacts on the profession. So a lot of people I know will probably argue that it sets a dangerous precedent because it creates a level of oversight over the role of a business rescue practitioner, not only in respect of the preservation of assets order, but because a curator is now appointed, which severely hampers their ability to do their work. But we have to ask ourselves the question, when has our industry ever seen a novel case such as the Optimum Coal case, where it's probably in the history of South Africa, we haven't seen state capture, particularly to this level, where it requires not only the interest of the NPA, but action from the NPA. So yes, there is corruption and maladministration, a lot in the public sector and somewhat in the corporate sector, but we have to ask ourselves, has that corruption or maladministration attracted the attention of the NPA, particularly in business rescue proceedings? I don't think we've ever seen one. So I don't think the profession needs to be quite worried about the precedent that this case may set just yet, because the Optimum Coal case in South Africa is a very unique case. We should worry when we see more cases like this coming to court where the curator is then appointed and preservation of assets orders are granted. But for now, I think we're safe.
Thank you very much. Cara, let's come to you and let's look at a statement that a lot of BRPs make, and when I engage with them, one of the comments that the statement that they make is that there are loopholes in the profession. We know where they are, and some of these loopholes relate to the legislative framework that governs the profession, as I pointed out earlier in my introduction. Can you please just discuss some of these major loopholes and what and that needs to be urgently addressed?
Thanks, Jonathan. Yeah, so I think due to the relative novelty of the business rescue, practice in South Africa and the legislation governing it, there's a lot of parts of the legislation that hasn't been tested by our courts yet, and that still needs to kind of stand the test of our courts to see whether they, hold up. So what this means is that a lot of the process is open to abuse by practitioners and by the companies themselves. And in fact, it's actually a lot of times the directors of the companies who would also abuse the process, specifically because they have very close and in-depth knowledge of the financials of the company, the other affairs of the company. So as much as it is the BRPs, it is also the directors of companies who abuse the process and try and find loopholes or use the loopholes to their benefit. So one of these, potential loopholes or areas of abuse is this moratorium on legal proceedings that is placed on the company once it goes into business rescue. So what we've seen is a lot of directors, but also business rescue practitioners, using this moratorium to essentially either prevent paying creditors at all or to delay paying creditors, and then essentially to delay or prevent the company from going into liquidation, where actually the liquidation of the company is inevitable and the business rescue proceedings was essentially a bit of a farce. So business rescue practitioners are definitely guilty of potentially avoiding creditors, not paying the creditors, and using the moratorium to delay payments and eventually to just enrich themselves through the process. Then another one of the loopholes potentially relates to Section 141 of the Companies Act. So what this section says is that the business rescue practitioner has a duty to investigate any potential suspicions of reckless trading or fraud or suspicious activity within the company. And if they do find that there has been suspicious activity by the directors of the company, they have to report this to the management, and then management has to report this to the authority. The issue at the moment is that the legislation doesn't actually make provisions for any specific steps that management needs to take to report this to the authority. And it also doesn't provide for any sanctions if they don't report it. So whereas with liquidation proceedings, you could have had an insolvency inquiry where directors could be held personally liable for reckless trading or fraud once these come out. In the case of business rescue, it often happens that this never comes to light, especially because the Act also doesn't make provision for the BRP or the business rescue practitioner to do anything other than just report it to management. So they don't have to report it to the authorities. And a lot of times the practitioner would just, wash their hands clean and say, I've done my part, it's now up to the management to take it further. Then I think another potential loophole, and definitely a big issue, which I think will be addressed potentially later as well, is the fact that the powers of business rescue practitioners are very wide in its ambit. The Companies Act gives them a lot of powers, and they also give the business rescue practitioners authority over a lot of directives or things that directors would usually need to do. So the day-to-day management of the company, if the director of the company wants to do something, they need to get authorization from the business rescue practitioners. Now, at the same time, the criteria that we use to decide whether someone can become a business rescue practitioner is equally wide. And this is potentially problematic because compiling a business rescue plan and implementing it is a very difficult and complex task. So not having sufficient criteria for who can and who cannot be a business rescue practitioner is very problematic, and it potentially leads to the whole business rescue plan failing and because of underqualified and incompetent business rescue practitioners being appointed. Another potential loophole issue is the fact of fees. So we've seen, especially in the media, sometimes business rescue practitioners charging very unreasonable fees. And at the moment, the legislation just doesn't make sufficient or doesn't sufficiently regulate the fees that business rescue practitioners can charge. So I think those are just a few of the potential issues. There's a lot more I can go on for a lot longer, but I think those are potentially the main ones that we need to address quite urgently.
Yeah. Just for clarification, when you refer to the authority, you are referring to the CIPC as the de facto regulator of the profession. Okay.
Yes, that's good. Yeah.
Awesome. Thank you very much. Muwanwa, let's come to you. So we've spoken about these challenges and these loopholes. So how do we expedite the development towards resolving this? Surely the profession cannot benefit anything or cannot benefit in any way from the loopholes that currently exist.
That is true. The profession definitely does not benefit. I think it is ultimately the legislature's responsibility for dealing with the avenues for abuse that stem from the business rescue proceedings. In many cases, these abuses go unnoticed, as Kara just said, and the courts have no way of stepping in and addressing the issues, as the judiciary only deals with matters that come to its attention. That's if it even comes to its attention. The legislature needs to issue regulations and/or amendments to the Act to specifically address the issues raised by Kara, such as ensuring that the BRPs properly assess whether a company should indeed be entering into business rescue or if the business rescue will be successful. Additionally, the legislature needs to introduce effective sanctions against BRPs, directors, and/or other persons who abuse the business rescue proceedings. Further, in order to ensure that sufficiently qualified persons are appointed as business rescue practitioners, the legislature should introduce more strident criteria as to who may be appointed as the BRP in the first place. A form of judicial oversight may be necessary to ensure that reckless trading, as Kara was talking about it, and fraud are not hidden away by the business rescue process. As I said earlier on, the profession definitely does not benefit from these loopholes, and it is important that the business rescue process is regarded as trustworthy and effective in both rescuing the company and/or ensuring a better return for the creditors.
At the results presentation of the 2022 Deloitte Restructuring Survey, one of the major sentiments during the panel discussion at that event was that there is a level of distrust in the industry that is building between the stakeholders, the lenders and the creditors of a company, and the BRPs once the company is put into business rescue. Talking to a BRP outside of the event, a statement was made that once a company goes into business rescue and the company is handed over to certain BRPs, these BRPs seemingly go rogue and they are a law unto themselves, answering to nobody. So let's interrogate this statement for a second. Firstly, do you find that is correct and that certain BRPs are going rogue?
So, Jonathan, I understand the results of the Deloitte Restructuring Survey, and I understand the growing gap in the trust with the business rescue practitioners and likely then the business rescue process. But let's just take a step back and consider all professions. If you look at the law profession, the accounting profession, and the journalism profession, or whatever, and not just point the fingers at the BRPs, there are a lot of instances where we find within those professions that we say those people or lawyers or attorneys or doctors have gone rogue per se because they haven't actually complied with the ethics of that profession, or they're just not suitably qualified or have the requisite skills. So essentially you are going to have some bad apples amongst the rest of the group. But it's always important to align yourself with attorneys that know good business rescue practitioners, because a good team of business rescue practitioners and lawyers can bring you a great success in business rescue. So if we can move on to what protections, but despite that, there are protections within the Companies Act that actually allows for lenders and creditors to protect themselves when they find that the business rescue practitioners have gone rogue. So in terms of Section 138 of the Act, it sets out who can actually become a business rescue practitioner, and it must be a member in good standing of the legal, accounting, or business management profession, which is accredited by CIPC. They must also be licensed as such by CIPC. So CIPC does have some regulatory oversight of the profession, but I would say who our best bet is with is our judicial system, because in terms of Section 130, an affected person may apply to court to set aside the appointment of a business rescue practitioner who has been appointed in terms of a board resolution, and they can do so on the basis that they do not satisfy the requirements for the appointment, they are not independent, or they do not have the requisite skills and knowledge to fulfill the appointment. You also have Section 139, who, upon the request of an affected person, can apply to court to have the practitioner removed if it's found that the practitioner is incompetent or fails to perform his duties, fails to exercise proper degree of care, engages in illegal conduct, or is no longer satisfies the requirements of a business rescue practitioner. So we must also then not forget one of the litigation that stemmed from the Gupta case is Knoop and another versus Gupta, which actually went to the SCA. And the SCA said that the High Court was actually wrong because there hadn't been a proper consideration of the evidence put forward, and that if we are to remove business rescue practitioners, it must be based on substantiated evidence which shows that they are not actually fit in terms of these requirements to act as BRPs.
So I think this answer is a very good advertisement for the legal side of the business rescue profession, and companies with a strong sort of legal and strong legal reputation. But also we must remember that BRPs do have a fiduciary duty and are answerable to the creditors and the lenders of the actual business rescue, because at the end of the day you're getting value for them. So going rogue at the end of the day, you have to answer to somebody.
Exactly, and that's why you have protections in terms of the Act.
Yeah, thank you very much, Roxanne. Cara, finally, let's come to you. One of the ways to combat all of this and this growing mistrust that we are seeing in the industry is to include a compulsory course of ethics within sort of the education side of going into the business rescue profession. And I would presume that in order to pass this ethics course, you would have to have a very high grade to pass it. And the BRPs would have to retake this course on every third year cycle and possibly retest it. Would the legal fraternity be involved in the profession? Would the legal fraternity involved in the profession welcome this? And would it be recommended that the legal fraternity be a significant contributor to the content of these courses?
Jonathan, to start off with, I think I should say that I'm not necessarily convinced about the efficacy of a course that is purely ethics-based. Just because, of course, there's one thing to know what ethical behavior is, and then it's quite another to actually act ethically. And there's always a risk that this course is then kind of seen by practitioners as just something to get out of the way, very similarly to how, for example, legal ethics courses are sometimes seen by law students at universities. What could potentially be very useful is to have a course that is in part focused on ethics, but then also focused on the general competence of a business rescue practitioner. So focused on how to compile a business rescue plan, how to effectively implement and execute on it. And I think this is definitely something that the legal fraternity would get behind and would also have to contribute toward in terms of the content thereof. So definitely in relation to the legislation and the interpretation thereof, as well as keeping abreast of legal developments in the field. So I think that's definitely a part where the legal fraternity can contribute. What could potentially also be useful is to get some economics and financial experts to contribute to some content in the course that deals with the finances of a business rescue plan and just basically going through the basics. So I think a course that covers ethics on the one hand, the law on the other, and then also the practicalities of the business rescue process could potentially be very efficient in ensuring that we don't have rogue practitioners, but also have practitioners who are suitably qualified and experienced. I think a potential question then is, if we do have such a course, no matter the content, who would be responsible for compiling the course and for administering the course? And at the moment, as Roxanne said, the Companies Act makes provision for the CIPC to license business rescue practitioners before they can become a business rescue practitioner. But I don't see the CIPC necessarily having the capacity to compile and completely administer a course like this, given that they have a lot of other functions that they also need to perform. A potential solution would be to have a company like a non-profit like Saripa work with CIPC, where Saripa is responsible for the administration of the course, and then CIPC essentially verifies the course and gives a practitioner a license after having successfully completed such a course. So I think something like that could potentially be very useful.
But I think there also needs to be involvement not only from Saripa, the other sort of industry professions such as the TMASA, SAICA and all the other ones, and possibly SACWA, who are involved, or the custodians of the continued professional development. And I think maybe the CPD would be a perfect way to get ethics to keep up on the ethical side of the profession.
Absolutely, yeah.
Awesome. Ladies, thank you very much for joining me today, for joining the front desk. I look forward to talking to CDH again later this month in a roundtable, which will go a little bit more in depth into some of the issues. And thank you very much for your time.
Thanks so much, Jonathan.
Thanks
for the opportunity.
Thanks, Jonathan.
Okay, have a good evening.
Thanks. Bye.
Okay, bye.